Good evening to everybody tonight. As you're joining, we're going to just give people a chance to sign on and join us. So we'll begin in a minute or so. Hello back at you, Sandra. We're just going to give people another minute or so to log on. Thanks for those of you who have logged on already. Thanks for joining us. So in one more minute, we'll get started. Okay, it's 6:32, so I'm going to begin. I want to welcome those of you who are joining us tonight. My name is Bill Barrett. Many of you I know. I want to thank you for joining us for sustaining your dental practice in the COVID-19 world. Tonight, I'll just be moderating as opposed to being a speaker. Most of you know a lot about our specialty in representing dentists and dental specialists around the country. We have the National Dental Law Center here at Mandelbaum Salzburg. And tonight, we're going to talk a bit about maximizing reimbursement from insurance carriers. And in this COVID world, we're seeing a huge increase in clawback cases with insurance carriers. So I think this is really timely information, and we're excited that you could all join us tonight. So I want to introduce our panelists. We have a great group tonight that's going to walk us through this. And I will give you a little bit of background on everyone. Damian Conforti is a partner in our firm and co-chair of the White Collar and Criminal Defense Practice Group. Damian is a former assistant prosecutor in New Jersey, so he understands the mentality of prosecutors and in dealing with dental fraud cases. He also frequently represents our dental clients in a wide range of white collar investigations and enforcement actions. We also have with us tonight another partner in the firm, Rob Scrivo. Robert is also co-chair of the White Collar and Criminal Defense Practice Group. And before joining our firm this year in January, Rob was an assistant United States attorney in the District of New Jersey. And earlier in his career, he served as a state prosecutor as well. Many of Rob's clients are licensed professionals, dentists in particular, so we're very excited to have Rob with us tonight. And last but certainly not least on our panel, Dr. Joan Monaco. Joan joins us from Horizon Blue Cross Blue Shield, New Jersey as the Director of Dental Operations. And Dr. Monaco was in private practice for many years and also worked for a large insurance carrier before starting her own consulting firm. She also worked for the New Jersey Dental Association before moving to Horizon Blue Cross Blue Shield. So we're really blessed to have Dr. Monaco with us tonight and to have the perspective coming, directly from the perspective of the carrier as well as a licensed professional. So it's just terrific. And so without further ado, why don't we move forward with our presentation. So I think a great place to kick it off would be with Joan. So let's start by asking the question, what is the most important thing a dentist can do to maximize their reimbursements?
It's a great question. In my opinion, I think the most important thing is the dental record. It is what protects you from malpractice cases. It is also what protects you from recovery from insurance companies. So it's really important that your dental record be very, very specific. And we are trained in school to be diligent about noting all the clinical things that we do, but there's additional information that needs to be included in that record that is really going to be crucial if you find yourself in a situation with, number one, malpractice, or number two, an insurance company doing an audit for you. So we can talk about some of those things. The basics, obviously, is that you need to have diagnostic information in that record. And I'm going to talk a little bit more about that in depth in just a second, but your clinical notes should be in there, of course, your treatment recommendations, and then whatever treatment you perform. Sometimes they're not the same thing, so that's super important. There should be a treatment plan in there, an ideal treatment plan, and then an alternate treatment plan, at the very least one alternate treatment plan. That includes proposed fees. So if your patient is a patient that has insurance or you're in network, sometimes you can't always gauge exactly what that fee is going to be, but you need to give them a ballpark figure, and it needs to be in writing. And then most important is consent forms. So there's a financial consent form, there's a treatment consent form, there are HIPAA consent forms. There's just, a slew of forms that everybody has to sign when they come into your office, but very, very important that you have all of those. Third-party payer paperwork is part of the patient record. So that means EOBs, whether they're electronic or paper, need to be in that record as well. And I'm going to backtrack for just a second. We talked about diagnostic information. We are really, really good at putting what we do in, the service that we provide, 2 or 3 carpules of xylocaine with 1 to 100 epinephrine, all of those details. But one of the most important and crucial things that you need to include in your record is diagnostic information, the why the patient is there for each particular visit, what that entails, and what your diagnosis is. So not what you're doing. They're not there for the root canal. Why are they there for the root canal? Is there periapical pathology? Was there a fracture? Was there pulpal, involvement? Whatever the case may be, the why is very important. I'll stop there for a second, though.
Joan, what are some of the more common record-keeping errors that you see that dentists make, or that they're maybe not even aware of that they've made the mistake?
Number one on the list is that the health history is not updated regularly. Okay, so this question comes up all the time. Do I have to update it every single time I see the patient? Actually, you should. Every single time you see the patient, you should ask the question, has there been any change in your medical history? It doesn't mean you need to have them fill out all brand new forms, but you need to document that you asked the question and then have them initial the chart, or if electronic, make sure that you put your initials in there as well, so that somebody can see that you actually did your due diligence and you asked. A lot of times patients don't realize that they changed their medication or they just got out of the hospital. They don't realize those things can be particularly crucial to the treatment that you're going to run. That's number one. The second one is that the treatment plan is not documented. Okay, so again, you need to have a treatment plan and an alternate treatment plan. It needs to include fees, but you should also include in there what the risks are. So if the patient accepts the treatment plan, that's one thing. If they don't accept the treatment plan, you want to be able to demonstrate that you did explain the risks to them and that they understood, they made an educated decision to not go forward with the treatment. And lastly, of course, is informed consent or informed refusal. If they refuse that treatment, to make sure that you have that documentation to show that you had the conversation, you explain the risks, and again, the patient decided or elected not to have that service, so that you can show that you did your due diligence. And of course, ultimately, at the end of the day, it's the patient's responsibility to make the decision that's in their best interest.
Okay. So moving on to a serious topic that no dentist wants to be associated with, but that they need to know about, which is, of course, allegations of billing fraud. We all know what amounts to intentional and obvious fraud. What are other ways insurers allege fraud that those watching tonight should be aware of? And what are your recommendations for guarding against these types of claims? How do we protect ourselves? How do doctors protect themselves from potential claims of fraud?
Okay, so there's a lot of misinformation out there, so it's a great question. I think how I, as a clinician, would define fraud would be very different than what an insurance carrier would consider fraud, or the Office of Insurance Fraud Prosecutor. So there's a disconnect there. We're speaking 2 different languages. And I think it's really important to kind of level the playing field. So first of all, only about 3 to 5% of healthcare fraud is detected, and dentistry is just a little pimple on the map. medicine really is where they get the most bang for their buck. So they go after the physicians more so than the dentists, but they're realizing that there is some money in dentistry. So they're starting to kind of pick up the pace and look at what we're doing a little bit more closely. The majority of the fraud is really just carried out by a small portion of the dental community. Sometimes it's because they don't understand. They've been doing the same thing for 25 years and they don't realize that they've been doing it incorrectly. Sometimes it's because your staff isn't trained, and that's not necessarily their fault. There is no official coding or certification course for a dental professional to take to understand how to code and how to document those things. So a lot of people learn as they go, trial and error. And then unfortunately, when it finally does catch up with them and you realize you've been doing something wrong for 25 years, that snowballs. The other thing is that a lot of dentists are in network with insurance companies. And when you sign that contract, it's not just about agreeing to certain fees. There are a slew of other things, provisions in that contract that bind you by law and by contract to the policies and guidelines that each insurance carrier has. And that relates to fraud, waste, and abuse as well. So they're looking at a lot of different things. You're obligated to provide a lot of information. Whether you're in network or out of network, if an insurance company contacts you and wants to audit you, it's in your best interest to actually participate and to be compliant. But there are some people that feel like, they don't need to. What I will tell you is if you submit an ADA claim form for reimbursement and the patient assigns benefits to you, then you are responsible. If you actually receive benefits from the insurance company, you are responsible and you're subject to an audit at that point. The only time you wouldn't be is if you were strictly fee for service, accepted cash and payment upfront from your patient, and then provided that documentation to the patient on their own behalf, and the check goes directly to them. So that's the only way you kind of get out of it nowadays.
I have a quick question.
Yeah, sure,
What
Bill.
are a couple? What's an example or a couple of things that would be in some of those in-network contracts that may, that, as you said, there's a slew of things in there that beyond the obvious that somebody might miss something like that, or just not be aware of something that's baked into that agreement.
Sure.
And
So-
one other thing I want to mention to everyone out there, if you do have a question, feel free to throw it into the Q&A and we'll answer that question as we go along. I should have said that in the beginning, so I want to say it now. But go ahead, Joan.
Sure. So there's all different provisions within the contract that you sign that says, in my mind, is it says straight out that if an insurance company comes back and asks you for money, if they're recovering money, you agree before anything to return that money, no questions asked. Okay, that's number one. For any reason, whether it's their mistake, it doesn't matter. You agree to return those monies, no questions asked. You agree to abide by their policies and guidelines as it relates to billing. And so there are provisions in there where sometimes you are disallowed from billing the patient for a service that wasn't covered, a legitimate service that has a code. But as a participating dentist, you have agreed to not pass that charge onto the patient, and therefore you have to write that off in negotiated fee. Just so you guys know, there's actually pending legislation in Trenton right now, a bill to kind of overturn that and prohibit insurance carriers from putting that language in their contracts. So if you're an NJDA member or an ADA member, you should follow that closely. This is landmark legislation that's really, really positive for the dental community. There are other things in that contract, like a favored nations clause, that basically says if you've agreed with another carrier to offer a service at a lower fee, that carrier can come back to you and demand that you deliver the same service at the same low fee to the patients as well. So let's say you're in network with MetLife and you agree to accept $100 for a crown, and you're in network with Delta and you get $1,200 for your crown. Delta can come back to you and say, hey, you're providing the same service for MetLife patients at a lower fee, and you can't discriminate against our patients. $100 fee for crowns for our patients as well. Right. So that's something that's in there. We don't see insurance carriers exercise the right to do that very much, but I wouldn't be surprised if we see that on the horizon. It's McCarran-Ferguson has been repealed. Again, if you're an ADA member, you should be aware of that. They finally repealed McCarran-Ferguson, which basically is an antitrust law, which means that you guys can now talk about fees. You can discuss fees. All right. And in the past that was prohibited, but now you actually have the ability to talk to your friends and colleagues and see what their fee schedules may look like or what they charge in their office for certain things, or hire a consultant that can negotiate fees for you and can compare. So those are really important pieces of legislation that are going to help you as a practitioner. But you need to understand that if you sign that contract and there's a provision in that contract, then you are agreeing, you are forfeiting your rights and you are agreeing to abide by that participation contract. I would recommend that if you're going to sign a contract, just about every dental association in the United States has a lawyer on staff, or you can send it directly to ADA and they will translate that contract for you into English, into layman's terms. So you understand what you're signing, have a summary for you that will give you the different provisions that are in there and whether or not you should maybe ask some additional questions, ask for clarification, make sure that you understand before you sign on the dotted line what you're agreeing to. So that's a really nice service that the American Dental Association offers to all dentists out there, and that's free. That's part of your membership. So I take advantage of that for sure.
Okay. So we're moving on to investigative techniques.
Mhm.
And Damian Conforti is going to present for us here. And I have a little bit of a kickoff question here, Damian. How do insurers investigate suspected fraudulent claims? And is there anything our attendees can do if they learn that their practice is under investigation?
Sure, Bill. Thank you. First, with respect to your first question regarding investigative techniques employed by insurers, they typically look for unusual trends or patterns in a dentist's billing, and they use some tools, as we've come to see, to track those trends in billing. First would be the use of the utilization review findings. As all of you are aware who are watching, insurers rely upon the opinions or thoughts of their own practitioners that they employ to manage your care. And if one of those practitioners were to identify an unusual pattern or suspicious treatment method, they'll cause a report to be issued down the hall to the insurer's special investigative unit. So that might be one way that a suspicion might arise. Another technique that we're seeing insurers commonly use is through the audit process. And that could be an audit of an individual claim, an audit of a wider collection of claims. But you should approach that and think about that audit to mean that there may be more to the audit than just an insurer simply looking to make a payment determination. They may be using or looking to use your response to the audit to collect data for broader purposes. So it's important to know that everyone who's subject to an audit, and that includes out-of-network providers, you can and you will be audited even as an out-of-network provider. The response you provide is critical. It's not limited to a question about payment of that particular claim or claims. Another technique is similar to audits, but now we've gone a step further, and there's an overpayment recovery request, or more commonly known as a clawback demand. So in this case, obviously the insurers made a determination that there was some amount of payment to the practice that should not have been made in the insurer's mind. What they'll do is they'll pay close attention to what you say or what you don't say when you respond to that clawback demand. Does the dentist simply write the check and repay the amount? That tells the insurer something right there. Does the dentist cause someone to call or write an angry letter back, and in the process make certain representations or give explanations for why his or her claims are justified? That's obviously giving up a lot of information right off the bat in response to what seemingly was an audit. A more obvious instance, if the insurer becomes aware of a misrepresentation or an attempt to conceal information about the patient's treatment, does the insurer have reason to believe that claims are based on those misrepresentations or the attempt to conceal the true nature of care? And this is, I say, more obvious because it typically comes to an insurer by way of a complaint from a third party, whether that be a patient or someone else. And I'll talk a little bit about that in a minute, a patient complaint. Another common technique in responding, or I should say an approach to responding, as Joan mentioned earlier, is the record keeping process. It's critical. It's critical to defending your insurance claims. Your ability to substantiate your claims or disprove an insurance investigator's claims begins and may end with the strength of your records that were created, hopefully contemporaneous with administering treatment. So I mentioned, how does these types of complaints involving fraud or erroneous complaints or erroneous claims, how do they come to an insurer in the first place? I talked about a whistleblower or a third-party complaint, but they don't solely rely, insurers don't solely rely on those. For baseball fans, like Major League Baseball has done over the past generation, is they study data and analytics. It's called sabermetrics if you're a baseball fan. And what they do with the data is they mine it. And they have management modules that are designed to identify dentists that are in the network that are outliers on specific utilization patterns. They take that information and then they calculate the financial impact of that outlier behavior. So is it worth their pursuit of a dentist, even if he or she is an outlier? They look at the actual impact that it's having on the insurer. How much are they paying out? They'll use patterns or analytics, again, to identify the potential for overutilization, upcoding, unbundling, and I'll come back to each of those in a minute. But the key here is the use of data has become a critical part of how an insurer can identify a potential problem in their mind. And they'll also use the provider profiles to form prospective or predictive modeling. And that way they can, in their mind, catch any fraudulent behavior before it happens. Again, through the utilization method, that can be done prospectively, as I'm sure all of you know. And they'll take the metrics that they are able to put together and they'll compare them to things like regional benchmarks to assist them in identifying potentially fraudulent or abusive behavior if it doesn't appear to be consistent with the common practice of your peers. And the determination, by the way, on what constitutes outlier behavior, that's determined based on the standard deviation from the mean. So again, it's very statistic oriented and it's very analytical. It doesn't always tell the true story. This is what they use to start an investigation, to cause an inquiry or an audit to be issued, and then they rely upon the response that they get to drill down and see what's really going on. It's really just sending out, a warning flare and see what we get back. A little bit of fishing. So we talked about some of the more obvious red flags, and a patient complaint being one of them. But it can also come through the records. Things that we always counsel dentists on staying away from is you don't want to slip up and try to pass one through. A falsified entry, for example. Is the dentist logging a procedure at the beginning of the year because perhaps the service was rendered at the end of the year and the patient had already exhausted his or her benefits? I mentioned upcoding. Upcoding is simply billing for more expensive services or procedures than were actually provided. It's often requires the accompanying inflation of the patient's diagnosis code to a more serious condition. So now we're doubling down on the problem if we're engaged in upcoding. And another easy way for investigators to detect potential cases of fraud is the waiver of copays. The concern here is that why is the dentist waiving the patient copay or deductible? Is that going to cause excessive billing or go down a slippery slope where services are provided that may not be necessary. You want to look to your policies. Insurers often set within the policy their particular specific policy or language with respect to waiver of copays. Under Medicare, routinely waiving copays is prohibited, and it's only permitted in the case of a financial hardship. So those are some of the techniques and the ways that insurers look to discover or dig down on fraud once they employ those techniques. Now, what happens when they determine or reach a determination that there's been deliberate or intentional misrepresentations, a true case of fraud? That's really where everyone needs to be on the lookout. It gives rise, in many cases, for a mandatory report. So carriers often become obligated to report suspected fraud to groups like insurance fraud prosecutors, which in turn can initiate a criminal investigation and seek penalties and fines. An insurer, or anyone for that matter, who suspects, and it's not knows or has confirmed fraud, has an obligation to report the offending dentist to a licensing board as well. So when we get to the avenue of deliberate or intentional fraud, it's not so much what can be done, it's that certain obligations kick in for the insurer. So Blake, if you could take us down to the next slide. Thank you. Where do we come in as attorneys that represent healthcare and dental providers? Well, we're called in the most obvious of instances when a referral to law enforcement has been made, or a referral to a unit like a Medicaid fraud division, for example. But we can also be of assistance, and I think provide a great service in the more common circumstances of an audit or an inquiry letter or a clawback demand. Often we advise practices on how to coordinate a response in a way that answers that inquiry and stops it from going any further beyond, say, an audit or a clawback demand. There's a couple of keys to have in mind if you're faced currently or in the future with this type of situation. When you receive an audit, think about coordinating an early response. It has to be coordinated because your first response is everything. It's critical. It sets the stage for what's going to happen, both in response to that audit and the way that the insurer is going to view your practice going forward. We like to take the approach of conducting our own investigation, and to the extent possible, uncover everything that there is to know before you even answer a single question that may come in the audit or the clawback demand. It's important to consider it as almost like a chess match. You need to be thinking 3 moves ahead so that the first response is one that sets you up to maintain credibility throughout the rest of the response. And you may not know all the facts. There may be a rogue employee that's involved. There may be a disgruntled patient who shared half the story and not the full story about what's actually gone on with respect to his or her care. So part of putting together that response and digging down on what really went on at the practice ahead of providing a response, we can act just like the insurers do. We also, like them, employ the use of metrics and analytics. We have our own form of sabermetrics, again, for the baseball fans. We use the same internal investigative techniques as tracking analytics, comparing the data to the mean. And oftentimes what we found is we present a very different story of what occurred and why. One example that comes to mind is there may be a lack of, as Joan mentioned, record keeping to support a particular code being built. But if we take a look at the code that was built and you look at the story for why it was built and why the practitioner thought that this was the appropriate practice, oftentimes we find that the reimbursement rate, it doesn't change, or any change in it is minimal. It's sort of a no harm, no foul situation. The fact that you don't understand an insurer's requirements to, the nth degree, or the latest changes in how you should be coding and what the law says about that, doesn't necessarily mean that you've committed an intentional or deliberate act that would require a clawback, let alone a referral to someone like an insurance fraud prosecutor. Another technique that we use is we employ as consultants former law enforcement agents who previously specialized in healthcare investigations or who worked for insurers in the same capacity that a special investigative unit currently works for an insurer. The same people who are pursuing the fraud claims. Those people we often seek out after having dealt with them and seeing that they're reputable and really good at what they do. They go into private practice or become consultants, and we use them to present our story, to do the metric analysis, to interview the patient that you feel may not be telling the full story or may be reacting to a negative experience for one reason other than anything having to do with fraud. Can also dig into investigators that we employ, that is, can dig into what's going on inside a practice. Do we have a rogue employee, as I mentioned before? Do we have a prevalent systemic problem within the practice that may have started for reasons having nothing to do with billing fraud, but are causing records to be kept in a way that lends itself to erroneous billing? That's often a very common mistake or occurrence at a busy practice. You're there trying to keep your chairs filled, and if you have associate dentists working with you to keep them busy, that's enough on your plate, especially in the COVID world, than to have to worry about the business side or the staffing side. And everyone knows with the strain that's been placed on dentists and the having to spend even more money now to keep that practice operating while servicing less patients, how difficult it can be to have enough resources on hand to keep tabs on all of the people and all the moving parts that are surrounding the business side of the practice. So coming in early and coordinating a response is not excessively spending on attorney's fees or consultants. It's often saving money in the long run because you're nipping something in the bud before it can become a larger problem. And you've taken a position or gone on record about something that perhaps is not beneficial to the practice or paints you in a bad light with the insurer. What are some of the more common ways that we look to resolve these inquiries or audits or investigations? So one way, if we've done our due diligence and we've been put in a position where we can really dig in and investigate the practice and get to the root of the problem, we may come to the dentist and say, look, self-disclosure here is a good thing for you. The insurer is knocking on the door of the problem, but they haven't gotten to the root of the problem like we have. And oftentimes by doing that, you're saving the insurer the headache. You look at it as a massive headache, which it is. They also look at it as the same vein. If you can save them on investigative costs, if you can deliver a comprehensive product to them that tells them everything that they may have suspected or disproves some things that they have suspected and maybe tells them some more, you're going to be in a position where you may be able to negotiate a percentage of the recovery sought. In addition to that, you're going to be able to dictate the narrative. So whether or not it's just money that they may be seeking initially, as I said before, you may look at an audit that way. It's the finding that could be reached against you that becomes even more critical. You want to stay in network. You want to be in good stead with Medicare. You want to avoid a referral to someone like an Office of Insurance Fraud Prosecutor. If we can dictate the narrative and explain why a discrepancy occurred, we can often, sort of quell the concerns of an insurer that what happened here does not amount to fraud. This is a mistake borne by other problems in the practice. So what's the next step in that procedure or that plan? oftentimes we put in a corrective action plan. So if the goal is to keep you billing and keep you in network, or to continue as an out-of-network provider, the goal for the insurer is to have some sort of comfort that moving forward, we've done this investigation now, we have the result, we know what transpired. How do we know and how do we have comfort moving forward with this dentist that the problem isn't going to repeat itself? We often present a corrective action plan that takes into account and is tailored to what the issues may be at the practice. Present that to the insurer and say, look, we've provided for these supports or these initiatives at the practice. The practice is committed to abiding by them. And you can know and understand that if we do that based on our findings or perhaps your findings, you're not going to have a problem with this provider moving forward. That takes the pressure off the insurer, as I said, and it allows for a positive continued relationship. So to just circle back, if you look at from the point that you're quote unquote under investigation through the time that you're able to deal with it internally and present a corrective action plan, it allows an insurer to know that this is someone I want in network. This is someone that I'm not going to have to be concerned about going forward. And it's a good business relationship all around on both sides of the aisle.
So Damien, you mentioned at one point in your discussion there that insurance carriers are obligated to report even suspected fraud to insurance prosecutors. So Rob, directing this to you as a former state and federal prosecutor, what can you tell the listeners about how prosecutors react or respond when they receive such a report?
Thank you, Bill. And good evening, everyone. Now that I'm on the defense side, I can tell you that all prosecutors are bad and overreaching people. I'm kidding. It's difficult to paint all prosecutors with a broad stroke. But when I look at the various insurance fraud prosecution acts around the states in the country, and you consider the healthcare laws as a whole, and you think about the investigative techniques that Damien just shared with us, I think it puts them in the catbird seat. And I say that based upon the question that you raise. The fact that insurance companies have affirmative obligations to raise fraud to prosecuting agencies. And I say that because the work of prosecutors in some respects is being done for them by the insurance companies. They have very sophisticated SIU units, and a lot of those folks who serve in those units are very experienced people, retired law enforcement officers who have worked in, for example, government offices, health and human services, and are familiar with the guidelines and familiar with the rules. So on the one hand, they'll have law enforcement officers and agents working with the prosecutors, but they'll also have insurance companies who can hand them ready-made cases on a silver platter. So in the one sense, it makes their job, I think, easier because they've got all that work being done for them. And their job then is to vet through it and decide, which cases they want to bring and which cases they want to reject and say, to the insurance companies, you're free to pursue your remedies civilly. Their job is also difficult, though, because their marching orders or their charge is not to decide whether to deny a claim. Their charge is to decide whether there's enough evidence to meet the standards of criminal prosecution. On the one hand, probable cause to issue a criminal complaint, or probable cause to present the evidence to a grand jury by which they should indict or should consider to indict. But more importantly, I think they really have to look at, and they do by and large, that I've been my experience, can they prove their case beyond a reasonable doubt to a jury of their peers? And I would hope that, prosecutors take those sorts of things into consideration. And I'm fortunate to say that, the diligent and careful prosecutors that I've had an opportunity to serve with, both in state and federal government, don't willy-nilly bring criminal charges against professionals like dentists, like doctors. They take their time. They review the written records that Dr. Monaco talked about, the claim forms. They study those forms. They match them against treatment records. And, here's an opportunity just to reinforce the point that Dr. Monaco made. Those treatment records provide a treasure trove for investigators, for prosecutors to look at. I had an experienced lawyer who I learned under one time when I was in private practice some years ago. He said to me, well, did you confirm it in writing? And I said, well, no, we had the conversation. It's not done. In many respects, you could think about it like that. If a dentist could say, well, I did this procedure, or I did this, but I didn't confirm it in my chart, you can almost look at it as it's not done because the proof doesn't exist that it's done. So they've got to look at the treatment records, and obviously, some dentists, some professionals are going to be more diligent than others. And then they're going to interview witnesses, including patients and dental staff, and no one wants that sort of thing. So the more your records are tight, the better off and the better position you're going to be to defend yourself. And I think by and large, prosecutors take a measured approach, and they should. And that's where defense attorneys come in, to hold them to their proofs and to engage them in discussions and test them, to recognize that, their job is not just to bring a case, to bring a charge based upon probable cause, but only to bring them if there is enough or more than enough evidence to prove those cases beyond a reasonable doubt. Because prosecutors also know, when we're dealing with licensed professionals like dentists, like doctors, just the charge alone and the publication of that charge through, through notice, whether it's picked up in the newspaper or on the insurance fraud prosecutor's website or the attorney general's website, is enough to ruin a dentist's reputation, and also will invoke an inquiry from the licensing board. So we like to get involved early in cases and investigations to put, our clients in the best position to fend off charges and help them deal with it if God forbid those charges do come down the road.
Great. So I think we're segueing to our last slide if we still have it. Here we go. Okay, so kind of shifting a little bit here, and I think Dr. Monaco and I will take a swipe at this, which is talking about kind of from the business side of things, how frauds or investigation for fraud or pending cases, how they might impact the ability to sell a practice or the valuation that a practice might have. It's a very timely issue because right now we're experiencing in dental and dental specialty the largest boom in mergers and acquisition activity that certainly we've ever seen. So it's an interesting time to talk about this. So Dr. Monaco, let me throw it at you first and get your thoughts on it.
Sure. So absolutely, this will affect it. Like you said, that we're seeing unprecedented consolidation in the state of New Jersey for sure. And basically that trend does go across the country after COVID. So, anytime that you're going to engage with a buyer and you're going to have your practice evaluated, it's going to be based on collection, production, and of course, some other things, but primarily your collections. And so if there's something pending with an insurance carrier where potentially you have to return monies, that is going to affect the value of your practice because that's going to come out of your earnings. And that goes back to production. It goes back to how your brokers evaluate things. It would be incredibly, I think, irresponsible for a buyer to enter into an agreement with you at that particular point in time because nothing's been settled. And potentially they could inherit that and inherit the devaluation of the practice in the process. So absolutely, it will affect the sale. It will affect the value of the practice. It potentially can affect you being able to either work for somebody else if you want to sell your practice and go on as an associate, and or just the reputation of the practice itself. So there's no guarantee patients are going to stay when you sell your practice, right? So you're really kind of you're evaluating. There's never that guarantee, and so potentially, if they know that this office was doing things that were less than ethical in terms of billing practices and things like that, you're potentially going to lose those patients as well. So absolutely, it affects it. I think that what people don't realize is when something like this is pending, it can take a long time for the case to come to fruition, right? So it's not like in 2 or 3 months it's going to be done. And a lot of times, if you have a buyer on the hook, they're not going to wait around. They're going to look for something else. So that's something else that you have to consider as well. It is, I think, crucial that you reach out to someone, whether it's, the attorneys that are on the call today or someone else. You cannot do this on your own. You should not attempt to do this on your own. I think that's one of the biggest mistakes we make as dentists. We feel that, perhaps we didn't do anything wrong or we didn't knowingly do anything wrong and that we can explain ourselves and it's just a need of clarification. But that's not usually the way it goes. And so save yourself the trouble and get representation and go into it with your eyes wide open. These are serious allegations. There's a big difference between fraud, waste, and abuse. But, there's 3 different levels that this carrier is going to look forward to. If they can't prove fraud, they'll go to waste and they'll go to abuse. And that may not mean that you get reported to the Office of Insurance Fraud Prosecutor or National Practitioner Data Bank, but it may mean a chunk of money out of your paycheck or out of the practice in order to settle the case. And so you have to be prepared for that as well. So absolutely, Bill, I hands down would say this is not something that anybody should enter into on their own. They should involve a team of people, including a broker, for the valuation process, and make sure that you have all your ducks in a row as you move forward with trying to sell your practice.
I think that I couldn't agree with you more. Those were all great points. And I had a transaction a few years ago where the client had an investigation and they were on appeal. They basically were trying to sell a very significant practice, and where it came out is, even though the whole thing was on appeal, and to your point, it takes a long time to get to a resolution. The buyer was either not willing to go forward, or if they were going to go forward, it was going to be with a enormous discount, because they basically were going to assume that everything that came from that investigation was correct, and that the practice needed to be discounted accordingly. And at that time, the client actually won the appeal, and the transaction ultimately went forward. In that case, it was a large transaction, went forward for millions of dollars additional consideration. But had it not been resolved, or had it been resolved in an adverse manner, it was going to cost this particular client millions of dollars. So it goes without saying that, it's really significant. Okay, well, I think we've covered all of our material. And I don't see any additional questions in the Q&A right now. So on behalf of our entire panel, I want to thank everyone for watching tonight. Especially, I want to thank Dr. Monaco as our special guest, giving us not only the great perspective as a practitioner, but also from the side of the insurance carriers. So it's really a great perspective for us to be able to have. And for the rest of our panel, thank you very much. And we hope everyone has a good night. Thanks for watching.
Thank you.